Well, hello and welcome to the Disability Law Show once again. Good to have you along. Hopefully you can stick around for the entire 30 minutes. John Scholes, Tamar, Agopian. Want to reach out to Tamar, of course, a disability lawyer at disabilityrights.ca. Always giving you the phone number off the top. The consultations are free. The conversations are easy at your own pace anytime. 1-855-821-5900. Help at disabilityrights.ca. Want to back that up with an email? Go ahead and do that. And we'll give those out throughout the half hour. A lot to cover on the show every half hour, every week, and we always have a main topic, which we'll get to in the second portion of the show. This week it is what you should know about a disabilities lawyer their role in an LTD claim. Informative stuff. We always here to dispel any myths or misconceptions about this world of disability law. And dealing with that disability insurer, that can be fun as a root canal sometimes, but that's why Tamar is here to help for sure. We'll get into that tomorrow, but you always get us warmed up with a success story, a week that was. What do you got going on this week, pal?
Right, so I'm getting really geared up for an upcoming mediation that I have.
Right.
For those who might not know what a mediation is, and I know you know what they are, John, but it is one of the main tools that we use to try and settle our matters that we have for our clients. And they are non-binding settlement meetings. So no judge, no courtroom. We just get together, typically virtually, and we try and resolve our claims. And in the context of doing that, we do a very deep dive into our clients' claims. We prepare a fairly comprehensive brief. We have meetings with our client. We look through the medical information. And I thought, in the context of our show, that I would actually highlight my client's situation, trying to keep it all private and confidential, of course, but really at a high level, because his situation gives rise to some really interesting issues because it has employment components and disability components. So he came to us a couple of years ago, actually. So it's been a long go for him. He had pretty involved poor diabetes control, which then set off a series of unfortunate health issues for him. He worked as essentially a trades salesperson. So it required him to be in his vehicle and going to the employer's different customers to sell goods and services. And so as you can imagine, when you've got diabetes, it is difficult to have set times where you can take breaks and eat and do all of those things to manage the diabetes, and his went out of whack. And for those who might understand this kind of condition, what it then will result in is actually some strange physical symptoms, some strange cognitive symptoms. Those who have those sugar highs and lows where they're not well controlled, it can actually have some pretty dire effects, and it can actually be fatal. And I say all of this because, of course, the insurance companies see diabetes and they think, well, this is a controlled type of condition. Surely with some dietary changes, maybe some insulin control, this should be something that he should be able to get a handle on. And unfortunately for my client, he did not. And he went through a series of unfortunate hospital attendances. I'm not going to get into all of it, but it ended up in him having to make a disability claim. And so where he started out was a short-term disability claim. And actually, he got stopped right there with the disability insurer. In this situation, the disability insurer was the administrator of the short-term claim, meaning they weren't actually the ones to have to pay it. So this is common, right, John? We see this quite a bit where we have a company, sometimes the insurance company, who gets to vet these disability claims for the employer for a variety of reasons, and they will make the determination on behalf of the employer as to whether or not this person is totally disabled, approved for the disability benefit, should be on claim. Right. And so the disability insurer did that for the employer, and they actually approved my client for a very brief period of time. And once they had approved it, those payments came from the employer. Stick with me, folks. This is why it covers so many different topics. Because long story long, he's denied short-term disability. The employer then stops paying him because they say, well, our administrator of our short-term plan says you're not disabled. You should be coming back to work. And in that time, my client's health takes a turn for the worse. He starts to experience mental health symptoms. He starts to have a deterioration in his health. He actually has to change doctors in the middle of all of this. And the insurance company denies his long-term disability claim as well. He was encouraged to apply. They said you didn't get the maximum short term, so therefore you don't get even out of the gates for the long term. But had he transitioned to long term, those funds would have come from the insurance company. Why is this significant? Because when he came to us to discuss the situation, one of the things we have to do, John, is always assess who is the target of the legal claim. What can we do here to assist someone in a situation like this? And because we do employment law and disability law, this puts us in a great position to be able to make that decision. And in his situation, our recommendation was you got to have both parties on the table, at the table. Insurance company as administrator and as the payer for long-term, and the employer who is also the payer of short-term disability. So all of this gets put into the big mix, and then he also gets terminated. So to add insult to injury, my poor client, after having gone all of these difficult health issues, having to go from doctor to doctor, finally gets a good doctor helping him, getting the resistance from the insurance company, he then got a lot of noise from the employer saying, but hey, all this time, we've been told that you are capable of working. Why aren't you back at work? They start sending him some very aggressive communications around disclosing his medical information and having to justify why he's on a medical leave. None of this is right. None of this is correct. None of this is legally correct, which is why we commenced the legal action. And he tried to appeal, but that didn't get him anywhere either.
Come on, really?
It didn't. And I think that it quite honestly, when I look back now in preparation for this mediation that's coming up, when I look at his medical records, it's very clear that what he was experiencing made things worse. We call that an exacerbation. That's the technical term. But that's compensable as well. The courts have recognized that if the insurer is making things worse, if the employer is making things worse, there's another bucket of compensation there available to this particular individual for all that he's been through and then some. So why do I lead off on this? Because there's a couple of key takeaways. First and foremost, I'm so glad this client reached out to us. I am so glad that he didn't wait so long that the time would have expired for him to actually pursue his legal rights. In the provinces that we operate in, and the big ones are Ontario, Alberta, and BC, but we really do work across the country, it is 2 years to start a legal claim. And it's 2 years from the moment that you are first denied. And what makes my client's situation a little bit unique is that that denial came through the short-term disability period, not the long-term disability period. And so why do I say that is because the time starts to run. So as he's going through short-term, as he's trying to deal with the employer, as he's applying for long-term, that time clock started to tick, 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 tick. And so this is why it's been a number of years to get to this point where we started the legal claim in time, thankfully, and now we've got all the parties coming to the table in a matter of weeks, and I can assure you we are going to be able to get the right responses. The conversations we really should be having, and should have quite frankly been having with my poor client is, look, where are you at from a health perspective? You know, can you provide us some updated medical information? They should have given my guy a fair shake and given him the time that he needed to actually get better. And in fact, he's gotten worse, and I think that's partly why they resisted his claim from the start. And so as I look towards this, I think the legal claim is important. I think the fact that he applied for long-term disability is important. And I think most importantly, he's come to a firm like ours where we can deal with all of the issues effectively to get him the compensation that he should have gotten years ago, quite frankly, from the start.
I find the interesting nugget in that, again, is where your client heard the fact that, you know, okay, well, apparently you got denied, so you should be able to come back to work. You should be healthy. No, that's not the that's not the opinion of the insurer that's up to. It's the opinion of the doctor. So they leapfrog that and just go, well, the insurer says you can come back to work, so come back to work. It's not up to them.
No.
It's not up to them.
No, you're absolutely right, John. It's not up to them. And so what made it difficult was that he was, don't forget, changing doctors around that critical point in time. And so the insurer didn't want to give him the time that he needed to get the new doctor in place, get the new doctor up to speed, so they could have that obsession around the paperwork in that point in time where he could have demonstrated to all of these parties, no, it's not up to you guys. You can't pressure me back to work. My doctors are the ones who should be advising me as to whether or not I should return. But that information is now available. So the information is now available, and the insurer and the employer have still both taken the poor decisions to do all of the things that they've done. And that too exposes them to a claim. Because the courts, when they comment on the conduct of a party, John, they're not just looking at the conduct of the party during the time where the claimant was dealing with them. It's also the conduct of the party during the legal claim. So even the way that these parties behave while they're dealing with us, while we've sued them, while we're dealing with the litigation, if this case goes to trial, all of that is fair game. I'm advancing that information to say, okay, maybe 2 years ago you did not have that information, insurance company, employer, but certainly you have that information now. And so why aren't you paying my client these benefits? And those will then naturally lead to the arguments around damages and additional compensation for my client.
Again, that's why we always tell you to reach out to Tamar and her team. It sounds confusing, but there is help out there, so use it. PocketDisabilityLawyer.ca, PocketDisabilityLawyer.ca. It's been around for a little while. Break it down, Tamar. I know you love the tool. How does it work? I
do. It's a really efficient way for people to find out what their rights are. It's essentially a drop-down menu with some plug-and-play information, very, very simple yes and no questions. And it's a starting point in my mind for people to determine, look, do I have a conversation that I need to have with a lawyer here? Do I have potentially a case? But if you're feeling sheepish about moving forward, that's okay. You can close out the browser. It's anonymous. We're none the wiser. But you can make that choice as well to have a conversation with one of us. It's absolutely free. But at least then it's a resource for you to start to see, look, what are the issues normally? When's the right moment for me to be contacting the firm?
Always time for an email before we break and get into our main topic from Joanna. Here it goes. A reminder as well, help@disabilityrights.ca. Joanna says, I have long COVID and several other medical conditions. I've been on LTD for 1.5 years and have consulted numerous doctors. Now my insurer is claiming, based on their doctors, that I have a mental illness. They're insisting I go for an IME, an independent medical examination, for a psychiatric evaluation. Can the insurance company require this when my own doctors have already stated there is no psychological condition? What do you think?
You know, John, I don't even know where to begin with this because I want to tell Joanna that she doesn't actually have to attend the IME, but I suspect that she's got one of those policies that allow the insurance company to force her to attend this kind of independent medical examination. And I tend to agree. If your own doctors are saying this is not a mental health condition, then why is it that the insurance company is insisting on this kind of an assessment? And it's because you're dealing with people who are not medical professionals. The adjusters that you have at the insurance companies, and they don't have the kind of background that your own doctors and therapists and treatment providers do, but they have a job to do. And that job is to try and bring your claim to a close. And so if you're in a situation like Joanna, there's a number of things that I would recommend. We've got a great memo on this on independent medical examinations on another website of ours called LTDFAQ.ca. But in the nutshell is this: you want your own doctors engaged in this process, because even if Joanna attends the IME, and it could be that the doctor recommends that she doesn't, and they could do a report and they can try and resist the insurer. But if you've got a policy that I've seen oftentimes that require this attendance, then you're going to end up with a report that the insurance company probably is going to be largely ineffectual. They may rely on it to actually cut off your benefits, Joanna, but at the end of the day, what weight is that going to be given? I can assure you that the courts have said that your own doctors, your own medical advice that you get from your own treatment providers is always going to be preferred. It's going to have greater weight in the eyes of the court as to your ongoing entitlement to benefits. And so the short answer is, I think Joanna probably has to grin and bear it and attend. And then the long answer is, well, if the insurance company then uses this IME to deny your benefits, then that, I think, is likely an improper denial, because your own doctors are saying this is long COVID, likely has all of the makings of these subjective symptoms, and those symptoms are probably what's keeping Joanna off work, and not because she's got a mental health condition.
Good opening salvo there, pal. We're going to take a short break, get lots more. Main topic just ahead, what you need to know about the lawyer's role in disability LTD claims. That is on the other side. In the meantime, always reach out to Tamar and her team. Phone call if you'd like to start off, 1-855-821-5900. And that email address, help@disabilityrights.ca. More of the Disability Law Show is just ahead. Stay with us.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back to the Disability Law Show. Tamar Agopian, reach out to Tamar anytime, disabilityrights.ca. She's willing to talk to you. By the way, the consultations are free. Just make that phone call. Maybe it's not that severe. You just want to have a chat. Maybe something about we've talked about on this show or a past show. No problem. 1-855-821-5900 to do that. Back it up with an email, help@disabilityrights.ca. Okay, main topic, as promised tomorrow, what you should know about a disability lawyer's role in LTD claims. You'll be able to wax philosophic on all these, no problem. First one, when's it actually beneficial to at least maybe not hire you right away, but speak to a disability lawyer?
Anytime.
All right,
Yeah,
moving on.
This one's quite easy because I think, quite frankly, people do feel a little bit unsure around when is the right time, and I want to dispel that notion. It is absolutely a myth. We're happy to speak to anyone at any point. Call us. As John just said, our consultations are absolutely free. We've got lots of different resources that you can access as well, but never hesitate. And here's the real reason why, and the insurance adjuster is not going to tell you this, but I'm certainly going to tell you this, which is this. There is a bit of an imbalance of power on it when it comes to the information that you're able to get as it relates to how to deal with a disability insurer. Your adjuster's not going to educate you on the process. You likely don't even have a copy of your policy. Even if you did, it has lots of words in it that you probably have never seen or are not familiar with, and that's okay. But what's not okay is blindly going along with what your insurance company is saying to you and ending up in a situation where they pull the plug, they cut off your benefits, or other things happen along the way. Maybe they pressure you back to work. There's lots of tactics that we talk about on the show. And the main takeaway is that we're happy to speak to you at any point in time, because you may need that guidance. And I think that when people hear lawyer, they get very nervous and, oh, well, I've got to start a claim and I don't want to sue my employer.
Court and everything else. Yeah.
None of that. And I think that this is why the shows that we do, the tools that we have are so important, is because people can take a look. You can see that there's nothing worrisome about it. And quite frankly, your adjuster insurance company, they don't even need to know that you've contacted us. But I'm going to be able to give good information to you on how to navigate this, or anybody on my team. And I think that initial step, though, has to be taken from claimants saying, you know what, I need to find out a little bit more about what my rights are.
Can you help out as a disability lawyer when it comes to the application process? Because that can be daunting, or even if there's a denial. How about that?
Look, I think there are certainly ways in which we can do that. We've got a team of people, John, lots of individuals who can support the process. I think the critical point in time, though, when I would probably be getting involved is in a denial. Not in the consultation phase. I talk to people all of the time, lots of people, every day, every week, every month. But in terms of that specific point in time in which I'm going to say to someone that I speak with, look, now is the time to retain us. It is because the plan will be to start that legal claim. And the starting point for that, from a legal rights perspective, is the denial or the cutoff point. And I want to just clarify one more point here, John, which is this. Some people are denied out of the gates, so they never get approved. That's a denial of disability benefits. Again, that denial in writing is what starts your legal right to start a legal claim. Other individuals will be approved for a period of time and then will be cut off down the road. I'm clarifying this because the legal effect is the same. At the point in time in which the insurance company has said, no, we're not going to pay you, either from the starting point or down the road, is when you want to assert those legal rights. Hire a good disability lawyer, have those consultations, and then let us take it away from you, and I will deal with it, and you don't have to deal with the insurance company.
One more question. This is the question that everybody's like waving at the TV going, ask this, and is the cost of a disability lawyer. How does that factor in?
Can I say this is my favorite question? Because this is how I answer the question. No fees, zero, nothing whatsoever, unless we are successful in getting a good result for you. So if my team is able to get compensation from the insurance company on your behalf, then fees apply. This is called a contingency fee arrangement. Again, lots of information on the internet and our website on this, but I think this is why it goes right back to the first question. When do I get you involved? Anytime. What does it cost? Nothing. Please don't hesitate. I think people need this help, because if they don't take that initial step, then they're left in a situation where they don't know how to navigate the insurer. They don't know what their options are.
Lots of regret.
And I don't want that, John. I want to avoid those regrets, because we are an approachable group. We're an extremely competent group. And at the very least, have that initial consult with us so that we can navigate this. And if we can help, we will.
Good stuff. We'll take another short break. More of your questions and emails just ahead on the Disability Law Show. Stay right with us. We're coming back.
People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
Alrighty, welcome back to the Disability Law Show. We got enough time for a couple questions. The first place we're going to go is yet another website you can use, free and anonymous, mydisabilityquestions.com. Mydisabilityquestions.com. For this week, Tamar, it's Wendy. She writes in, says, I'm a special education teacher, currently on unpaid medical leave because my benefits company denied my claim. I've already provided them with a letter from my rheumatologist confirming I have fibromyalgia, osteoarthritis, and lupus. After appealing their decision, the company responded by requesting additional information. Are there other options available to me?
Wendy's email dovetails quite nicely with what we were talking about, in our prior segment. The idea of what are my options in a situation like this. And so I want to start with number one, saying why the appeal process can be frustrating. And it's exactly for this reason, folks. Wendy is being asked to submit more medical information, even more medical information. Please send us more stuff. And that tires people out. That tires your practitioners out. And that exercise really is driven entirely by the insurance company. And so Wendy would have received a denial letter. In that denial letter, it would have given her an explanation as to why she was denied, and then it will talk about this appeal process. But if I look at that policy, that appeal process won't be in that policy. This is a system, a process that the insurance companies have conceived of to essentially persuade you that this is the best way to continue to try and assert your rights and try and be able to get your disability benefits paid or payable. And I cannot disagree more, because this is not something that has any sort of checks and balances. Whereas if you retain us, retain a disability lawyer, and start that legal claim, there are lots of checks and balances in the legal process. First of all, there's very specific timelines in which the insurance company has to respond. There are specific things they have to disclose. There's mutuality. In other words, there's a bit more balance in terms of who's saying what to whom in terms of those timelines. I mean, I could go on, and we have so much information here. But the key here is that the options should not be, well, I'm going to keep appealing and waiting for the insurance company to, please, can you look at this again and maybe come to a different conclusion? Because the legal claim will force them to do that, John. It puts it in the hands of one of their lawyers in-house, usually. There's a specific person at the insurance company who's assigned, who can understand all of the legalities, all of the risks involved in pursuing a legal claim like this, and it's efficient. Because Wendy tells us that she's been on an unpaid medical leave. I can only imagine how many months, maybe even up to a year. Well, we can have the legal claim resolved in that time. And in that time will be all of the leverage points that we like to talk about, all of the things that we discuss in terms of getting the right reports. We coordinate those things with her own doctor, her own rheumatologist, and we get across to them that claims like Wendy's, when she talks to us about fibromyalgia, osteoarthritis, lupus, these are all inherently subjective claims. So I'm not surprised she's getting resistance from the disability insurer on a claim like this, because they're not things that can be tested like an X-ray, even MRI reports and this sort of thing. And so the account, her account, and the account of her doctors and treatment providers become very important in trying to explain to the insurance company this is a payable disability claim. But I don't want to see Wendy having to do this herself, which is why the legal claim becomes so critical, and the appeal process is a waste of time.
Yeah. I want to get to one more email before we wrap for this show, Tamar, from Christian. Again, help@disabilityrights.ca. Christian says, I've been on LT for 6 years now due to rheumatoid arthritis and was recently approved for CPP disability. Despite this, the insurance company keeps asking me for constant updates about my condition. I always fulfill requests for paperwork, but it's always the same answer. No change. I'm limited in the medications I can take, and I have surgery coming up soon. Why does the insurer keep harassing me for more info?
They're obsessed with paperwork, John, because, again, they have a job to do. And that job is to determine whether you are totally disabled each and every month before they release that monthly disability benefit. And so some adjudicators are much more aggressive. Others are a little bit more lax in terms of the timeframes in which they need this paperwork, but they always need the paperwork. And so in a context like this, here's what's interesting about Christian's claim. He's been on disability for 6 years. He's also CPP approved. That means the government has recognized that he's got a severe and prolonged disability. In the context of that, to me, it's a no-brainer that he should be on long-term disability, probably for a heck of a long time. And I suspect the reason why the insurance company is being so aggressive about the paperwork is because they're looking for opportunities to try and cut off what is otherwise a plain and obvious long-duration claim. These disability policies will pay you until you're 65 years old if you can demonstrate that you're totally disabled through that whole period of time. Now, I don't know how old Christian is, but John, I've got to assume that he's been in this process for a while. And what's unfortunately not happening from the insurance company's perspective is this idea that maybe we just need a yearly check-in with Christian. And so why are they being so vigorous? My concern is, are they still looking for that opportunity to cut off? They probably are. And so what can Christian do? You have to keep cooperating, unfortunately. Yeah. I mean, I think there's no two ways about that, because as I said before, if you want your long-term disability benefits to continue, that paperwork needs to be present and available to the insurance company in that context. The other thing I would say is that, what's harassment? I picked up on that word, because if it's plain and obvious that there are no changes and the updates have been the same, but you've got an adjuster perhaps who's being inappropriate or aggressive or in conversations is not being fair in terms of dealing with Christian, then that's also something that raises a bit of a red flag. Is this something that Christian needs to raise with a supervisor, someone more superior than the person he's dealing with, and ask the plain question, look, why do you need all of this information? Nothing has changed. And, can we make it maybe every 3 months, every 6 months in terms of these responses to a situation where it's clearly that he's, going to be on claim for a long time.
And CPP is a good thing as we wrap up here. CPP is a good thing.
Absolutely.
It's a tougher test, generally.
It is a tougher test because the test is that he's got a severe and prolonged disability, whereas the test for the insurance company is, are you totally disabled from doing your occupation or any occupation? Right. So just the words alone will create that helpful leverage to say, well, that test is tougher, so certainly that means I should have my long-term disability continue. And look, the insurance company gets a credit for it anyway, so why are they getting so hot and bothered about continuing Christian's disability claim?
And with that, Christian and Wendy, both of you, thank you so much for reaching out on both those fronts. You can do it again, and maybe yourself will get on the show in the future. MyDisabilityQuestions.com or help@disabilityrights.ca. That's the email address. Always reach out to Tamar, like we said throughout the entire show. Free consultations as well. 1-855-821-5900. So there you go. You're set for another week. We'll catch you next week here on the Disability Law Show. Enjoy the rest of your week.